thought this was set for a plea.
Well, it was, so they withdrew the
I'll
offer.
give the court explanation, Your Honor.
It was gonna.
Judge, we discussed what I thought was going to be a solid agreement, and then after reviewing jail disciplinary, I just didn't think the court would approve it. So I upped my offer, which is being refused.
Now, just to be clear, Your Honor, I had gotten Mr. Nichols to extend an offer of 4 years, which Mr. Carter was prepared to accept, and that's when I set it on the docket today to plea. I was contacted by Mr. Nichols yesterday and advised that he was withdrawing that offer based upon the jail write-ups, which I've been provided with, and that the offer was now 6 years and with a 7-year cap, and Mr. Carter previously refused 5 years, so I did another refusal.
So, Mr. Carter, how old are you?
17.
17 years old. And do you realize now what you acting up in jail has already cost you? Do you really? Tell me what it's cost you. Well, some of your life. But you had already talked about a deal in your case that sounds like you were going to accept. Is that right? And because you can't behave and follow the rules in jail, and I get those reports, and the district attorney's office gets those reports, and your attorney gets those reports, they decided you don't deserve that, and I don't disagree with them. So here's what happens now. If your case goes to trial, and I'm going to go through some things in a few minutes about that, and you get found guilty in that trial, that jury can also hear all of those reports, every last one of them. And if you think this man right here ain't going to bring those in and show that jury why you don't deserve any mercy or whatever, he's going to do it. I would if I were him. So if you're going to be in front of a jury, or you're going to be in front of the judge, or someone who's deciding what happens to your life, you might ought to change what you're doing in that jail. I just had a talk with another young one. I don't know what's going on in that dorm with all of you young ones, but what y'all all need to do is look at each other and say, I don't want to go to prison for a long time. If you do, you go act up over there. And man up and say, I'm not going to behave like that. Because you're a man now. And you're in felony court. You don't feel like a man. Your brain's probably not functioning like a man. But you are in felony court like every other grown-up man. And if you make kid decisions and think that horseplaying and treating the people that are trying to work there the way you are is going to get you anywhere, it will. It's going to get you in there longer. Does that make sense? So what you're charged with is the third-degree felony offense of deadly conduct discharging a firearm from October 13th of 2024. And what that means...
Judge, I'm sorry to interrupt again.
Yes.
He has a juvenile adjudication, which he is actually on parole for.
Felony conviction.
And that's a felony conviction. My understanding, and I need to file the proper notice, my understanding is that can be used to enhance him to a second degree. I don't think it precludes him from maybe getting probation from a jury. I need to make sure I vet that out through the family code.
Okay.
But my understanding is he's looking at a possible second-degree punishment range.
Do you agree with that?
It's a hybrid situation with the prior juvenile felony conviction. I think that Mr. Nichols is correct that it precludes, or it does not preclude him from having to be eligible for probation from a jury. However, it will enhance the punishment range from a third degree to a second degree.
So, Mr. Carter, what that means is that if you go to trial and a jury finds you guilty, and they find that that previous adjudication took place and was true, that you were adjudicated as a juvenile of a felony, that means that jury can sentence you anywhere in the range of punishment of a second-degree felony instead of a third, which is between 2 years and up to 20 years in prison. Do you understand? And I have a plea bargain rejection that you've signed with Mr. Kimler that shows that the district attorney's made an offer, if you wanted to enter a plea of guilty, for a 6-year term in prison or for a 7-year cap to me. You have every right to reject that offer and have your case set for trial. We've talked about all that. Do you want to reject that offer and have a jury decide? Okay, then we'll get your case set on the trial docket as quickly as we can. Again, Don't get over there and forget what I told you today. It's very important. Do you understand? Okay, go back with the bailiff. Good morning, sir. You're Alejandro Uribe?
Yes, ma'am.
And Mr. Uribe, you were previously in court, entered a plea of guilty to aggravated assault with a deadly weapon. The agreement was for 5-year deferred adjudicated probation, and I received that pre-sentence report. Has everyone had an opportunity to review the report?
We have, Judge. Yes, sir.
So I guess my issues, or my only issue with going forward with this agreement is your status. You're not here, it appears as though you're not here in the United States legally, and that you've been removed before and there's an ICE hold on you now. Is that correct? So, I mean, what does given a probation do? Just give him a probation and he gets deported and it sits on, we just let it go till he comes back again illegally or legally?
I'm not coming back.
I mean, there's ways to do it, obviously,
Right.
legally, but, okay. I mean, do you think the best thing is to go forward with
I would just proceed on, Judge.
the plea? I mean, if you do get out, so let's just do this. We'll just go forward with the plea, and then whatever happens, obviously in federal court or with any type of new charges over there. It looks like I have been handed an arrest warrant from the United States District Court, Eastern District. So I think you will probably be taken from here. If there's a hold on you, you'll go straight over into custody, federal custody, and whatever happens over there happens. What I'm going to do is go along with this agreement. I'm going to give you a probation. If for some reason you get out during this probation period and you're here in Texas, then you obviously are required to go to probation, do everything you're supposed to, because if you don't, you could end up in prison for a very long time on this case. So what I'm going to do is find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, at this time, I'm going to follow the agreement, defer all proceedings, place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation if that becomes an opportunity for you. Obviously, if you do that, in this case, this is an excellent opportunity because you don't have this conviction on your record. And again, the other side of that, however, is if you do get out and you are here and you do not comply with the conditions of probation, you can be brought back into this court, found guilty of this offense, and sentenced anywhere in the range of punishment, which is up to 20 years in prison. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Probation will go over your documents with you today, and then we'll just see what happens, all right? You can give that back to Mr. Coleman. Thank you. Good morning. Are you Demetrius Miles?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Here we go.
Mr. Miles, in cause number 24 DCCR 2478, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon. That's from November 26th of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Objection.
It's admitted. Is Mr. Miles, is there any evidence of Mr. Miles not being competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in your case. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. All right, are you Gabrielle Smith?
Yes, ma'am.
And Ms. Smith, you were previously in court and entered a plea of guilty to the second-degree felony offense of robbery. The agreement was for a cap of 5 years in the institutional division of the Texas Department of Corrections. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
I have, Judge, if I may, for the court, my initial correspondence with Mr. Rojas was that she possibly had a tremendous amount of history out of Louisiana that I just couldn't get a grasp on based on the NCIC that I had. Obviously, now probation has successfully done that, and I'm not sure that coupled with her behavior in the jail is even appropriate for the 5-year sentence. I agree with you that it's not.
It's not, yeah. I don't think it is either. So, Ms. Smith, your criminal history is pages and pages long. Hold on.
I'm sorry.
You have felony 1, 2, 3, 4, 5, 6, 7. You have 7 prior felonies for theft of goods.
Judge, I think
That's wrong.
I was going over the PSI with you yesterday. By my count, I think we may have 4. Some of those are repeats, if I'm reading this right.
Yeah, that's wrong.
Well, if you look at the first page of felonies, she was sentenced to 12-month parish. That's not, it's called parish prison, but I think that's actually a misdemeanor.
Okay, so let's.
So that one I don't think would count. On the second page, if you look at the first conviction, which is 1, 2, 3, 4, 5 down.
Well, the very top one is
Okay, that one's well. Yeah.
a year in Department of Corrections.
And then the next one is number 5 down. That's the same one, I think, as 1, 2, 3, 4 down. That's the same amount of restitution, same time sentenced. And she said that was all the same case.
I've been locked up since 2016 to 19, and all those were supposed to be, from my understanding, I don't know what you call it when they.
So let's take one of those out that it's a mistake, okay? Let's take
nowhere near 7.
And then the same thing with the
1,
next
2.
following 2.
So it's 4 or 5. 1.
They all.
2,
What I'm saying is they're all.
Just because they ran at this, listen, just because your time ran at the same time doesn't mean that you weren't out there committing the same thing. Don't talk over me. Over and over and over again. The misdemeanors alone, I've got at least 8 theft misdemeanors, at least 4 stand up.
I'm sorry.
At least 4 Okay. At least 4 felonies. I'm not going to accept the agreement for a cap of 5 years. I do not think that is appropriate in your case, based on the nature of this offense, based on your underlying criminal history, based on jail incident reports that I've received. So I'm rejecting that offer, allowing you to withdraw your plea. I'm going to reset your case. You guys can negotiate. If y'all come up with something different that the state thinks is appropriate, then I will look at that at that time. You can go back with the bailiff.
I still have my bond. I still have a bond.
You have your bond is set at $7,000.
No, it was 10,000, but you did 1,000 for the.
You said a PSI bond.
Yeah, a PSI
Because
bond.
I'm withdrawing the PSI bond at this time. I am finding, based on the information that I have received in your pre-sentence report, that is insufficient. And at this time, I'm raising your bond to $40,000.
Ma'am,
you can go back with the bailiff.
10,000. I'm not understanding how.
Well, what we didn't know, and what I didn't know, and what Ms. Molfino didn't know at the time that this offer was made, was the extent of your criminal history in Louisiana.
Okay. Well,
so go back with the.
Can I ask you one more question?
What? Yes.
My original charge of assault on a police officer is not a robbery. She told me that I can, get re-indicted for
assault on a police officer. I'm not understanding.
Judge, that was also my
Yeah, I'm
correspondence.
not.
Hold on, and when someone else, I let you talk. And so when someone else is talking, you let them talk, all right? That's respectful for everyone. I gave you an opportunity to let Ms. Malfino answer.
Judge, in my review of the file, I think the case can be charged as either one. Obviously, with her criminal history, would show the amount of theft. This was an instance that was underlying of a theft that either got out of control and could be indicted as a robbery or an assault on a public servant. They're both the same second degree.
Right.
We will also, if we can't reach an equitable agreement that the court agrees with, be moving to use those Louisiana prior to the answer.
Okay, all right. Mr. Rojas will go over all of that with you. You can go back with the bailiff.
I don't understand.
Ms. Smith, come back. Ms. Smith, come back. Come back.
I just don't understand.
You cannot understand, but you're going to be respectful in this court.
I'm respectful.
You're not
Okay,
being
I'm sorry.
respectful.
I'm sorry.
Because I think you do understand, because this isn't your first time being in a court of law. You've been in it numerous times in Louisiana, all right? When you walk out of here, you walk out quiet. There's no attitude, because things can get worse and worse and worse instead of better and better and better, right? Go back with the bailiff. Let's try it again.
And there it is, a courtroom moment that strips away the noise and leaves only consequence. Deals collapse, sentences grow, and futures quietly tilt because of choices made when no one thought they mattered. In this room, age is not a shield, excuses don't soften impact, and behavior writes its own evidence. The law doesn't argue with potential, it responds to patterns. And when the gavel moves on, one question lingers. Will this be the moment that changes you, or the warning you ignored, long after courtroom doors close?